Mr. Kobe?
Mr. Chief Justice, and may it please the Court. This Court should adhere to the objective reasonableness standard for emergency aid entries set out in Brigham City, rather than require what petitioner calls probable cause of a danger. Petitioner's theory has no basis in the Fourth Amendment's text, which links probable cause to warrants, not to searches in general. History doesn't support petitioner's theory either. The framers adopted the Fourth Amendment to guard against overzealous criminal investigation, not to hamstring officers from providing life-saving aid to people in need. Yet petitioner's rule would make it harder for government officials to help people in crisis, from victims of domestic violence to older people who have fallen and can't get up. This Court should instead reaffirm that emergency aid entries are assessed for reasonableness, a flexible determination that accounts for both the severity of a danger and its likelihood. States are always free to craft their own rules above that constitutional floor, but the Fourth Amendment does not categorically require probable cause of a danger for an emergency entry. I welcome the Court's questions.
Should we apply this rule here or send it back?
We think you should apply this rule here. I think there has been some question about the Montana Supreme Court's use of the word suspect in its test, but I would urge this Court not to read a decision like a statute, especially because elsewhere in the decision, the Montana Supreme Court said that its test largely mirrored the Ninth Circuit's test, which uses the objectively reasonable basis for believing language, and because it used other verbs elsewhere besides suspect. I think PEDAP 14A footnote 5, they say there was an objectively reasonable basis for finding a danger. So I would avoid sending it back just on the basis of that word suspect or